Sir, do not come before me and tell me that as a tenant, you're not given a chance, not before me, because that doesn't happen before me.
Your Honor, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. You now want to insult me by saying that somehow or another you don't get a fair hearing when you came here. When you came here the first time, I told you what I would do. I read your motion. I went through everything to see whether or not there had been something, because you claimed a number of defects. I then bring you back here, have treated you fairly, have listened to everything you have said. And how dare you say to this court that somehow and or another you don't get a fair hearing for me? I've made my rule. I'm done. Thank you. I suggest that you close your mouth as you leave, because otherwise you're going to be going with my bailiff.
Good morning, Your Honor. Jackie Snyder, Potter, standing in for Attorney Lasbury for plaintiff.
Miss Edwards?
Yes.
Good morning. All right. Okay. Almost afraid to ask, but where are we?
We're not in a good spot, Your Honor.
Okay.
There's a smell. They went in on Wednesday to do a spray, and Miss Edwards did leave the unit with her cat. However, it didn't appear that the unit had been vacuumed or prepped for the spraying. So they did do spraying, but she's supposed to be vacuuming and keeping up with laundry and stuff like that. And upon management trying to enter the unit, there was a smell, and they weren't not able to enter the unit due to the smell to do an inspection.
Gotcha. Okay. Miss Edwards?
Yes, Your Honor.
What's your position on this?
That I have been trying for some time, and I'm still trying to get home help, which I desperately need. And one of the things that I have been told is that nobody is going to send anybody in here until the bed bugs are gone.
Okay, but we're at a point now where the conditions keep existing, and I don't.
And Your Honor, if I may, she was receiving assistance, or at least the presence of assistance, from the Housing Bureau for Seniors. And they indicated that they're unable to assist her anymore due to her not cooperating with requests.
Got it. Okay, so
It was due to me not cooperating with requests.
pardon?
The woman from the Housing Bureau for Seniors did not tell me that it was due to not cooperating. I just want to get that in there.
Okay, but that's what they're telling the landlord, that you're not cooperating with them, so they can't provide assistance.
I don't know in what way I haven't cooperated with the service agency. And I've tried to talk to Renee also and ask for a little bit more time, and she has refused.
Okay, but Miss Edwards?
Yes.
Here's what the problem is. The landlord has been trying to work with you. I've been also cajoling them to try to work this out, given your circumstances, because there really wasn't any issue for me to try on the case. I was hoping that what we could do was resolve the entirety of this matter, give you time to heal and get services in there for you. But at every turn, and when I bring the case back up, it appears that those services aren't coming in for you, and that the conditions of the premises continue to get worse, or they improve, but then they go right back to where they are, that the landlord can't do the extermination because of the condition of the unit, we were able to get the unit into one, or at least get, I think, one dose of extermination because we got the unit in a condition that it could be. But then for the second treatment, that couldn't happen because the unit had to be maintained in a certain way. And so now we're at a position where there's not a whole lot else I can do.
Excuse me, I would disagree that they were not able to come in for a second treatment. I believe they were in here because when I came back, the bed bugs were just all over out in the open, which they were hiding before, apparently, because I didn't see them that much. But there was a distinct change. And I really am waiting on these agencies. I mean, Pace told me that they can't send anyone in until the bed bugs are completely gone. I've applied for help from DHS. I haven't heard back from them. Their process can be kind of slow. And I only got the letter from them with the application in it about a week ago. So, I filled it out and sent it back, and I don't know when I will have a response to that. I've also called other agencies. I've called Hawk. I've called the Community Action Network of Washtenaw County. I've called my insurance. I've called Washtenaw County Environmental Health, the Hoarding Task Force, and Jewish Family Services. And I have not had response from any of those as of now. And I know, these agencies are overwhelmed at this point. I understand that. So I'm not faulting them, but I just don't know what I can do to speed up the process with getting help, because I really need help from an outside source.
And I'm aware of that, Ms. Edwards, and we've been trying now we'll be going into our third month of really trying to do this, and we can't continue to go on this way. Nobody wants to have you evicted from the premises, but the premises can't continue to exist in the way that it is. It just can't. And so what I'm going to do, as I indicated before, there was really never a tribal issue. We were just trying to resolve the matter. And so what I'm going to do is I'm going to issue a judgment for possession to the plaintiff, finding no tribal issue. A writ will not issue until the 15th of March. So I'm going to give you a little bit more time. And so what I'm going to suggest to you, Ms. Edwards, is that you just continue to contact these agencies, see if you can get someone in there, get a plan developed, and then get that to Rose Community, and maybe they won't then issue the order of eviction. But at this point, ma'am, that's basically all that I can do. I can't continue to ask the landlord to wait and to try to do things. In all honesty, they've gone overboard. They've done more than what they certainly legally would be required to do. And so I applaud them. I applaud them for that. But, at some point it comes to the end of the road. This was going to resolve one way or another. And now we're just at that point. All right. So I'm going to issue that judgment. I'll sign it when it's presented to the court. Ms. Edwards, I just wish you the best of luck. Okay.
So if I can manage to get some help before the 15th, how do I get that information to you?
Well, you need to get it to the landlord, because it's going to be, you need to get that to them, and then they're going to make a decision which is in their interest as to what they do. But You're gonna have to have something in place and it's gonna have to work out. That's what we've been trying to do and it hasn't worked out so far, but I'd suggest that you get to these agencies and then contact your landlord and see if you can work with them. Okay?
Okay, thank you.
All right. Thank you. Good luck.
Thank you, Your Honor.
Thank you. Harbor One West versus Jack, is it Wazorek?
We did that last time.
Yeah, no, I'll get it eventually, but then by that time the case will be done. Come on up.
Everybody does. Everybody messes up.
Morning, Your Honor.
All right,
Cheryl
sta-
Walkup on behalf of the plaintiff.
State your name, sir.
Jack Wazorek.
Okay. And where are we on this? Was this his motion?
Your Honor, it was, I don't think he can argue the motion. There was a motion filed that was drafted clearly by legal aid, but signed by Mr. Wazorek. This was a health hazard due to bed bugs and roaches and the landlord not being able to access the premises and the premises not being available denying entry and not being prepped. We took a default judgment and I know Your Honor wanted to review this and that's where we were last week. It's landlord's
Right.
position. Go ahead.
Go ahead.
I was just say it's landlord's position. We want possession of the premises. We've had chronic issues with housekeeping, cleanliness. It's not fair to the other residents. This is an ongoing problem. I'm very willing and ready to argue that Park Forest does not apply to a health hazard. So I'm going to leave it to you what you want to hear, but I am strongly requesting a judgment here to stand.
Sure, go ahead.
Your Honor, I have had RPI in there twice inspecting my place. They never came in.
They being who?
Arbor One
Okay.
never came in. Wendy, the assistant manager, I told her that wasn't a problem. The garbage bags, like I told you last week, were not garbage. They described them as garbage. Those were pots and pans and stuff we had to put in the bags because they wanted to do a cockroach inspection. 6.5 years, I've never seen a cockroach. They turned it into, well, it's garbage. There's garbage all over the house. They never brought anybody in. I had paid a lady, a friend of mine, $100 after that to come in and make sure everything was in line. You got an affidavit from legal aid showing that RPI been in there twice and gave me a pass inspection. They passed me twice. Arbor One has never come in to my house. Wendy told me she got the report on a Friday. She said she'd have somebody in there Monday. Nobody ever showed up at all to do an inspection at all. I had to call RPI when I got the court judgment and bring them in on it, which I told Arbor One, I told the assistant manager, Wendy, I wouldn't get Arbor One into it if we could help it. She wouldn't let it go. I've been having problems with maintenance in there since 6.5 years. I've been having problems with maintenance. All I'm trying to do is keep a good place. Arbor One, RPI come in there twice. They said the inspection passed inspection. So they never come in. Arbor One never came in and did any kind of inspection at all.
Your
They
Honor,
just
if I may
went
just
by-
respond to this. First of all, I don't know what affidavit Mr. Wazorek is talking about. Second of all, we're talking apples and oranges here. We're not talking about RPI. We're talking about bed bugs. We're talking about the treatment provider came to the unit on 2/2, was denied access, and then
But
came
that
back
wasn't,
of the
That
that
hearing.
wasn't the original.
Sir,
Judge
sir,
Barr.
I can, let Ms. Luckoff go. I let you go for a while. I just want to, go ahead, Ms. Luckoff.
The date of the hearing in front of Judge Barr, they were again denied entry. This is, and there are bed bugs in the unit. And this is multifamily living. I don't have to tell the court that's not fair to the other residents. So we are asking that the judgment stand and we recover possession of the unit.
Your Honor, they
Sir,
called me
sir, what affidavit? Because I don't have,
because there was
I
one
don't
from,
have an affidavit either.
there's one from legal aid. They sent you a paperwork over. They sent you a bunch of paperwork over.
Who did?
Illegal aid,
Sent me?
yes. Yes. That's who I received my, that I was supposed to see you about.
Sir, hold on a moment. The only thing that I've received that I have in the court file, the only thing that I've received was the motion to set aside default supplement. And that's the document that's signed.
I have all the paperwork in my briefcase that I can show you.
Okay, but sir, did you let the treatment providers in?
They were told,
That's a yes or no.
yes.
When you
Not,
let them,
not at the time that they actually came the first two times when we were in court. Excuse me, Your Honor, but it's important that this is clarified. On the second, they were denied entry, and then on the court hearing date, which would have been the 16th, they were denied entry.
I
So
never denied
after the
them
fact,
entry.
after the judgment was entered, they were permitted entry. Because
So they were
I never
the
denied-
obligation,
sir, they were denied entry on the 2nd and the 16th,
correct.
or the, yeah, the
And that's the
16th.
date of the hearing was the 16th.
Incorrect.
So did they come in on the 2nd, sir?
No, they talked to my son at the office. And he told them we weren't ready at that time. That he wasn't
Okay,
part of that.
that's a denial of entry.
I never denied him entry.
Well,
They never
Not-
came to my door.
if you're not ready for the treatment, that's a denial of entry.
But that was through my son, not
On the
me.
16th,
On the 16th, I told him he could come in. I told him inspect if you want. I said, could you wait off for a couple hours? I'm at court with Zoom, on Zoom, with the other court.
so
with the
they
other
were,
officer,
so
with the other
hold on a
judge.
second, sir. So what I'm hearing you tell me is that on that date, the unit wasn't ready to be sprayed either.
Yes, it was ready to be sprayed. We
Then-
just had.
Then
to-
why were you asking them to wait?
Just because I was in court at court at that time. And they never gave me no warning that he was showing up or coming. It's supposed to take 24 hours notice. I didn't get no notice. They
That's
just
not-
popped in the door. I had to go to court on Zoom with the other judge. I was there. I did not deny them entry. I told them, yes, if you want to come in and inspect, come on, inspect. I said, but can you wait until a couple hours to spray till I'm done with court? They don't give me no time. They want to do it when they want to do it. They want to just.
Exactly, sir.
Oh.
Exactly, sir. They needed to come in and do the treatment.
But they don't understand that we have a house, we have to maintain ourselves. And when I'm on court, on Zoom, on the phone, all I'm asking for, I'll move out. I just need more time.
That's what
But
he
that's
said
what
2
they
weeks
want.
ago.
If they want me to move out, I'll move out. I just need more time to do it. Because see, the assistant manager, I don't know if this lawyer knows it or not, but they called,
When are you gonna move?
I don't know yet.
Okay, let me put it to you real straightforward. I've listened to what you told me. I've looked at everything in the file, and both of those 2 times would be considered a denial of entry for treatment of the premises.
This is where the case takes a major turn. The judge has now reviewed the prior hearing, listened to both sides, and is focusing on one issue above everything else: access for extermination. In landlord-tenant disputes involving bed bug infestations, courts often view denied access very seriously because the problem doesn't stay confined to one apartment. It can affect an entire building. What's hurting the tenant's position here is that every explanation seems to introduce a new detail rather than directly addressing the judge's central concern. At this stage, The court isn't debating maintenance complaints from years ago. It's deciding whether treatment was prevented from happening. What do you think? Should the tenant's explanations have been enough to earn more time? Or is the judge right to focus strictly on the access issue?
But Your Honor, they didn't even start with the bed bugs at all.
Sir, if you can argue with me all you want, I'm telling you what I'm finding.
Well, do I have a right to get a lawyer or go to trial with this? Because this ain't right. This is not right. I've been haunted by this company for maintenance. The first
Sir,
maintenance
sir,
problem
sir,
started years
Sir,
ago.
sir. I'm explaining to you what my finding is. Now, if you want, you have a lot of opportunities to do what you want to do. I don't have a problem with that. All right, I'm explaining to you what my findings are. Understood? Is that a yes?
Yes, yes.
So what I'm trying to find in that the Judge Barr found that they were entitled to that, the writ should be signed. You have indicated to me that you will move, but that you needed time. So my question to you is, how much time did you need to move?
At least till like June.
Well, that's not going to happen.
Okay, because what it is Wendy, their assistant manager, called me last night at 7:00 and told me the lawyer told them they were coming in to exterminate today. I told him, yeah. I said, I'm not going to be there. I'm going to be at court, but they have access to come in and spray. And I'm asking, why would they do that if they're going to want us out anyways?
Because the problem that's causes problems for all of the other residents. If your unit doesn't get exterminated, everybody else in that building has a problem. That's why.
Right, I understand that. I understand that. I've been self-exterminating myself before they ever showed up. I was self-exterminating with Orthex or whatever it is. I paid $20 a gallon for it. It just didn't totally eliminate it. And I know what the problem is. I have to get rid of one of my couch. My couch is a major problem with them. And I'm getting rid of the couch this month. I needed money to buy another couch. And that's a major problem. It's right there. They're all in the couch. There's nowhere else in the house that they're accumulating that, just in there. And the other problem is the people that moved out before me in the building across the hall, they moved out 3 months before Arbor One discovered they moved, and they had to remove their couch and love seat because they left it behind.
Okay. All of that's fine. The problem is that the landlord, you objected when you came in here to the hearing that took place before Judge Barr. That's what you were giving me, which is the only reason that I set this where I did. The problem here is that there was a denial of entry to the premises.
But that one ain't on the court docket.
It just is. It is what it is, sir.
But Your Honor, what I'm trying to say though is through the original judgment, it was over garbage bags. It wasn't over bed bugs. And they said we didn't prep for the bed bugs the first time. When they gave the court order, they never gave me a prep sheet. They never told me. They said, oh, go back to your prep sheet in December. We never got a prep sheet in December at all. They started this in January, and they said, go back to your prep sheet you got in December to prep it. Well, I never got no prep sheet on bed bugs. We get a prep sheet on cockroaches, which is total different prep. It's a total different prep for cockroaches and bed bugs. We never received a prep sheet for bed bugs. So we didn't know what to prep. So how can I bring them in and say, yeah, we're prepped, when I don't have a prep sheet to know how to prep it or what they want for prep? And even the exterminator came in there and I asked him, are you doing bed bugs and cockroaches? He said, no. He said, I didn't even get a work order on bed bugs. They didn't even get a work order on it.
Your Honor,
Sir,
you want
let me just say this. Every time I tell you what I'm finding, you keep telling me something new. It doesn't work that way.
But you're going to
I'm
only
dealing-
2 times, Your Honor. They're going to, you're only going to 2
Now,
times.
you can keep interrupting me all you want.
I'm sorry. I'm
Not-
sorry.
It's not going to change my decision.
I'm sorry. It's just,
There was a hearing that was held on this. The hearing, I don't find a defect in the hearing. I don't find a defect in the hearing. The judgment will stand, the writ will issue.
You can hear the frustration building on both sides now. The tenant is focused on the long history of maintenance issues, the fear of losing Section 8 assistance, and the consequences an eviction could have on future housing opportunities. The judge, however, is looking at a much narrower legal question. Once a court finds that proper notice was given and access was denied for a health-related treatment, overturning that judgment becomes extremely difficult. The emotional reality and the legal reality don't always line up, and that's exactly what we're seeing here. The tenant feels unheard, while the judge believes he's already reviewed every argument available. Cases like this are a reminder that courtroom outcomes often depend less on how strongly someone feels and more on what can be legally proven.
how long?
I'm done. The writ issues. It's the statutory, there's no period, sir. There was a hearing that was held.
Well, how long do I have to move? I'm saying, how long are they gonna give me
I've
time?
just signed the writ, sir. So you're operating on borrowed time.
Well, because I'm gonna lose my Section 8. If this writ goes through, I lose my Section 8. And I have no other way of paying my rent or anything. I've been there 6.5 years. Paid my rent, never gave a problem at all to them. And because of bed bugs, they're supposed to eliminate. I'm being accused of something I didn't even do. I haven't even done anything that is causes warrant for me to be evicted. That's why I'm asking. I just need a little more time, yeah. You know, I need at least a month. And now, if they're causing on a writ, that means they're evicting me. No place is gonna touch me with an eviction. You understand what I'm saying? I go to some place, tell them, oh, I got evicted. I'm hit. I'm 60 years old. I don't have time for that. I was trying to retire. I told them up front, I would work with them on stuff. I said, no problem. I'll work with you. We got to work with it, work with it. Yeah, I don't know what else to say. I would never given a lawyer. I have to sit here and defend a lawyer when I don't have that kind of smarts. You know, I'm not that smart to deal with a lawyer. You know, and I'm not even given a chance for a.
Sir, do not come before me and tell me that as a tenant, you're not given a chance, not before me, because that doesn't happen before me.
Your Honor, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. You now want to insult me by saying that somehow or another you don't get a fair hearing when you came here. When you came here the first time, I told you what I would do. I read your motion. I went through everything to see whether or not there had been something, because you claimed a number of defects. I then bring you back here, have treated you fairly, have listened to everything you have said. And how dare you say to this court that somehow and or another you don't get a fair hearing for me? I've made my ruling. I'm done. Thank you.
Still feel like my rights were violated.
I'd suggest that you close your mouth as you leave, because otherwise you're going to be going with my bailiff.
In the end, the court allowed the eviction judgment to stand. The judge found that there was no defect in the prior proceedings and concluded that the landlord had established sufficient grounds based on repeated issues surrounding access for bedbug treatment. Despite the tenant's claims regarding maintenance problems, preparation instructions, and concerns about losing housing assistance, those arguments were not enough to change the court's decision. The most dramatic moment came when the judge pushed back against suggestions that the tenant hadn't been given a fair opportunity to be heard, emphasizing that he had reviewed the filings, reopened the matter, and allowed extensive argument before making his ruling. This case highlights a difficult reality in landlord-tenant court. Health and safety issues affecting multiple residents can quickly outweigh other disputes, and once a judgment is entered, reversing it becomes an uphill battle. What was your takeaway from this hearing? Did the judge reach the right decision, or should the tenant have been given one last chance? If you enjoyed this courtroom breakdown, be sure to like the video, share it with someone who follows real-life legal drama, and subscribe to the channel for more intense courtroom moments, unexpected rulings, and in-depth case analysis. Your support helps us bring you more fascinating cases every day.